And then I'm going to just do a brief introduction and then we're going to get started. So welcome everyone. Just want to tell you I'm a little bit about who we are at Dancing Sky. I'm Amy Dahlman and I'm a program developer with Dancing Sky Area Agency on Aging. And for those of you not familiar, Dancing Sky is one of 7 area agencies on aging in the state of Minnesota. And we cover the largest landmass of the area agencies on aging. We cover 21 counties in Northwest and West Central Minnesota. And really, our main mission is keeping older adults healthy, active, independent, and involved in their communities. And we offer many services. And if I went into all of them right now, we wouldn't get to the main point of the webinar. So I'm just going to touch on 2 things real quick. One is that the Senior Linkage Line is one of our programs. And again, that's a toll-free statewide number. People can call for help, questions, resource, referral, and it's just a great place for people to start. And then another thing I want to mention is we do quite a few of these educational webinars. We kind of shifted gears. We used to do more things in person, but obviously with COVID, we've done more virtual things, and webinars is one of them. And so, like I said, we offer all kinds of educational topics. We've done on scams, we've done on hospice versus palliative care. We have some coming up about spring cleaning. We have all kinds of wide range of topics. So really watch our Facebook page, which I also put in the chat, because that's where we're going to be advertising those. And then also want to mention that during the presentation, we will be taking questions via chat. So if you have a question, feel free to pop that in the chat and I'll be monitoring that. And Anne and Joy have given me permission to kind of just interrupt them on occasion to address those questions. So we will be doing that. And then let me see if I missed anything. Otherwise, I'm going to just go ahead and introduce our speakers. So we have Anne Hofgren. Anne is the Executive Director of Legal Services of Northwest Minnesota. Anne joined Legal Services as a staff attorney in 2004, and in that role has advised and represented clients in district court and administrative hearings with critical civil legal needs, including housing, family law, domestic violence, unemployment compensation, consumer law, and public benefits issues. And she lives in Fargo with her spouse and children and their mini Labradoodle. And then we also have Joy. Joy Mickles is an elder law attorney and public benefits attorney with Legal Services of Northwest Minnesota. And she previously practiced for over 14 years as a public defender in Clay County, Monoman County, and Fairbanks, Alaska. Joy lives in Moorhead with her husband and 2 children. So I'm going to let them take away. They're going to share their screen. But again, just a reminder, feel free to put things in chat and we will address them as we move along.
Thanks, Amy. And thanks everybody for having us here today. I just want to reiterate that we are happy to take questions throughout this presentation. In fact, I think making it as interactive as possible as we all stare at these little boxes. I would really push for questions. Even if you want to just throw me like a softball question, just to keep the conversation going and then interrupt my flow, feel free to do that too. So, and I may interrupt Joy because that's just what we're going to do. We work with Legal Services of Northwest Minnesota. We are a nonprofit law firm that helps people in non-criminal issues. So low income and seniors in non-criminal issues, really focusing on basic human needs, safe housing, safe family relationships, income stability, and things along that line. And later, the Dancing Sky covers 21 counties. We cover 22. So we basically overlap the service area of Land of the Dancing Sky, and we're really happy to be a partner with them in things like this. So we, again, provide free legal help to low-income families and seniors in those types of cases, but we also do public education and push out information to try and prevent legal issues before they happen. And this is one of those circumstances and why we are here today. So I am going to go ahead and share my screen. And Joy, just interrupt whenever you want to. So I'll keep talking. I also talk relatively quickly. I'm trying very hard to not. but that is my nature. So there you go. It tells me participants can see my screen. That is us. So today we're going to talk about advanced directives. So just as an overview, what is an advanced directive and why are we going to talk about them? I'll sort of like lay the stage for us here before we get into the two particular documents we're going to talk about. Advanced directives, as the name suggests, are things that are done in advance of incapacity. That means we have to plan ahead. We need to make decisions and execute these documents while we still have capacity. Capacity means the physical or mental ability to do something. We'll talk a little bit about that more as we go. But they must be, these are both documents that have to be completed by someone when they still understand what they're doing. What power am I giving to people when I sign these documents? So what are the two documents we're going to talk about today? We're going to talk about healthcare directives for medical decisions. And sometimes people have, these documents are referred to as a healthcare power of attorney or a living will. I am not going to use those terms because I think they're extremely confusing, because a will is something different. So living will is just confuses me. And healthcare power of attorney confuses that power of attorney document. So we're going to really separate these documents and these conversation into healthcare directives. And every time you hear me say healthcare directive, it should be obvious, we're thinking medical decisions. Healthcare directive is medical decisions. Joy is going to talk about power of attorney. So every time you hear the words power of attorney, that is only going to be about money and property. Money and property, or healthcare. So those are the two different types of documents. And we've separated them out in that way. And again, healthcare directives used to be called living wills. I am not going to say that because I think that just is really exhausting and confusing for everybody.
Anne?
Yes.
We have a question already.
Oh, good. Thank you.
The question is, does this requirement vary from state to state?
Which requirement?
I'm not sure which requirement.
Here's what I'll say. They are documents that are created by state law. So every state law is going to be a little bit different. So yes, whatever requirement that is, it's going to be, this is a Minnesota, we're focusing on Minnesota healthcare directives and Minnesota power of attorneys and the forms that go along with it accordingly. There are lots of similarities though. I am only licensed to practice in Minnesota, but there are lots of similarities. I live in North Dakota, so I have a North Dakota power of attorney with my spouse, and it's very similar. And full disclosure, I don't have a healthcare directive. I have admitted this, and I am full disclosure. I have plenty of blank copies of the documents and I just haven't done it. So do what I say, not what I do, I guess. I will say is, yes, Amy.
She did clarify, it says completed before incapacity. That part does that vary?
Yes, I believe that's going to be every state, because by definition, these are documents for people with capacity, with the understanding of you are giving away power or sharing power. In the case of a power of attorney, which Joy will talk about later, you can share that power or you give it to someone else to do when you don't understand or are unable to make those decisions yourself. So that doing it while you understand it is sort of the point of the documents. Doing it now when you're in a calm place to think about what you're doing is a big part of it. And we'll talk more about that as we go forward. So yes, there may be some slight differences with regards to how does this document need to be witnessed? So for example, the Minnesota healthcare directive can either have a notary, so who witnesses your signature and stamps it as officially as a notary saying, I checked your ID and I saw that you signed it, or you can have two separate witnesses, right? So that little detail of how the law requires them to be executed may vary from state to state. But I think the general concept of advanced directives, healthcare directives is similar, that you must be understanding of what you're doing when you do these documents, as much as any of us understand these really hard decisions going forward. Okay, there we go. So I already said this a little bit. Again, they're created by state law and they have to comply with state law. And I don't want to get out of my screen sharing now, but I do have copies of the documents, and there's a link in the PowerPoint which we can share where people can get to the form document. In both cases, these are written documents that have some minimum requirements under the law, but they're forms. You know, they are, you can be flexible and you can make them meet your needs, but they're form documents. No one needs to start writing this from scratch. And certainly people can pay attorneys to do these documents. Again, and I know I'm an attorney, so it's easier for me to say, it doesn't feel like a good use of dollars in my sense. Sorry to all my private attorney friends. They are form documents. If you understand what you're doing, they are not particularly complex legally. They're actually, I think, more complex emotionally, spiritually, and through personal dynamics and personal relationships. That's the complexity, I think, in these documents, not so much the legal components of them. And as we talk about scenarios and come up with examples, I think we'll see why that is the case. So for both documents, they are written, they are documents. They have to comply with state law, so they're witnessed. In both documents, both powers of attorney, again, when I say power of attorney, we're all thinking property, finances, and healthcare directives, medical decisions. Both of those advanced directives can be modified and can be terminated while you have capacity. When you still understand it, you might change your mind. And again, we'll talk about why you might change your mind about something in the future. But the other thing I would say about both documents is if you complete a document, you need to share those documents with people, right? So if you have a document that explains what you want for your medical wishes, and you fill it out in private, and you, I don't know, have your two neighbors witness it, and you put it in a drawer and nobody knows that that document exists, then when it's needed, no one's going to know it exists and no one's going to know how to find it. So we will probably repeat this point multiple times, but having that document be available in the places and with the people who need to have it easily available is an important part of both of these documents. Otherwise, it's kind of like a tree falls in the forest. If a healthcare directive is in your drawer, nobody knows it's there, does it exist? People can't follow a document they don't know exists. So that's kind of a high level overview over both documents and some similarities. Now I'm going to get into some of the specifics and some of the issues that arise with a healthcare directive. So as I said, it's a legal document that you have to do before you are incapacitated. If there is concern about someone's ability to understand and have capacity, that's where problems could arise later. So say your adult parent is having some dementia issues or having Alzheimer issues. If that document gets challenged in the future and they say mom didn't understand what she was signing, that's where things get ugly, right? Now, that doesn't mean somebody who has some dementia doesn't understand and can't do the document. That's really more of a medical decision, like a doctor as opposed to a lawyer. Lawyers that do these documents, have conversations with people to see, do you understand who you're giving this power to and what this power is? That's where that capacity issue comes in. And for healthcare directives, the power isn't given to somebody until after you become incapacitated, after you are physically or mentally unable to make those healthcare decisions for yourself. So while I'm up and talking to my doctors, it doesn't matter what my healthcare directive says. I am fully able to make those decisions myself. The directive gets triggered when there is some concern that I am unable to make those decisions for myself, either because I am unconscious, very clear, I can't make those decisions. A doctor can't ask me a question I can't answer because I'm unconscious, or if there is a mental capacity issue and the doctor is saying, does someone else have the power to make these decisions? I don't believe this person understands the choices they have medically. And what they are is they're written instructions about medical care, right? So that's what it is. So there are two things you can do in a healthcare directive. One is you can simply appoint a person to make those decisions for you again, when you're unable to make them for yourself. As long as you're able to make them for yourself, you don't need that other person. But you can appoint what they call a healthcare agent. That agent is an adult, someone over 18, who's available to act in your best interest and to make the decisions that you would make for yourself if you were able to. And this is not a legal requirement, but this is where the real life comes in, right? You have to talk to that person about, do they want to be your healthcare agent? Are they comfortable making those decisions? Are they going to be available, both sort of physically available, but also kind of emotionally available to make those decisions? And would that person make the decisions that you want them to make? They're acting as if they were you. And the example I use sometimes is that I have a friend who is a Jehovah's Witness, and Jehovah's Witnesses do not believe in blood transfusions. And so she has said, I cannot have my spouse, who's not a Jehovah's Witness, be my healthcare agent, because I know if I need a blood transfusion, I myself wouldn't want it because of my spiritual beliefs. I don't know why that's all popping up. And he would give me he would tell the doctor, yes, give her a blood transfusion if that's what she needs. Right? So it's a very obvious example of where the person's healthcare agent would not be a good healthcare agent because they're at odds with what that person wants. And that's where having those conversations and choosing someone who you think can make those decisions, that's the tricky part, right? Of course. The other thing your healthcare directive could do is it could give directions to your medical providers about what level of care you want. And the document itself, which we can show you later, gives you sort of triggers for this, gives you kind of a fill in the blank of a sense. What would you want if, I thought I turned that off, you guys, sorry about that. Not sure if I know how to turn off all my notifications here, but for example, it could, the document itself is like, here's how I believe about living longer. Here's how I believe about pain management. And it, what are my goals for my healthcare? What's my fears for my healthcare? It's a particularly unlegal document in that way. Most legal documents aren't so kind of, how would I say, touchy-feely, right? How do I want to handle my medical care? But the document itself talks about that. So again, in a healthcare directive, you can either appoint a person to just make all those decisions for you when you're not able, or write down how you feel about medical care, or both. You can have a healthcare agent who also has directions from you in the document. So I sort of already said that, but again, you name a person and you give that power to someone else. And that's when you giving that power to someone else when you're not able to have it. It's only when you're not able to make those healthcare decisions for yourself. And again, it only comes when you're not able to make those decisions. The few limitations on who that person can be is it can't be your medical provider. You can't choose your doctor to be your healthcare agent unless they also happen to be a close family member, right? If your daughter is a doctor, you can certainly choose your daughter, but you can't just choose your doctor because you want your doctor to make all the decisions for you. Okay. And again, when does that agent get the power to make those decisions for you? Either when a doctor says this person can't make those choices anymore, or you can have a triggering event in the document. So again, why are they helpful? And I know this is a little repetitive, but it's when you can't speak for yourself, and it's setting up your healthcare to be followed in a way that you want it to be followed. And why would we do this? Why would you give someone else that power? You know, a lot of times it's a really unfortunate, these are healthcare crises. If I'm not able to talk for myself, that's either because I have a mental inability to understand what's going on, or I am in a real healthcare crisis. So it's not the best time, right? To be trying to decide among, for example, 4 siblings, who's going to decide what happens to mom's care at this time. It really is a time when people are in crisis and they're maybe not at their best. And I think people think, well, my kids get along great. But what we don't want, and what you've heard those stories about those fights in the hallways of a hospital when one sibling is saying, I think this is what mom wants, and the other sibling is saying, nope, I think this is what mom wants. And people who get along great in a non-crisis time may or may not get along in a crisis situation. And you need to pick somebody who would act, who really does understand your wishes and who would follow your wishes, which leads to that non-legal part of having that conversation. I think the story that I think about, some of you may be familiar with, is the Terry Shriver situation. This is probably 20 or 30 years ago now. It was a very young woman who had a medical crisis, a stroke or something like that. And her husband said, we've had this conversation and she would not want to live this way. She was in kind of a semi-vegetative state, and her parents understandably weren't ready to let go. And they said, we want to do everything to keep her alive. And it became a court battle, and it became a protracted, I mean, it doesn't always happen this way, but a protracted court battle. And I think that's not how most of us would want to spend the end of our life, is having our families fight each other. So not saying that would happen to anyone's family, but that's the reason for that healthcare directive, is to educate your family on what you would like. A couple things to add before I turn it over to Joy. If there's other questions, feel free to interrupt. You know, knowing that you can and should change this document is an important part of it too. I mentioned that earlier, that all these documents could be changed. The healthcare directive that I promise I will write in 2022 is probably not going to be seen as the same healthcare directive that I might write in 30 years when I'm in my 80s. So like many of these legal documents, your will, your any kind of planning documents, looking at them every couple of years and thinking, are these still accurate, is a really important part of those documents. So I talk about the agent as well, because it may be that you choose one of your adult children to be your agent today. And if that child moves out of the country and is no longer available, or for whatever reason, you don't, they're not available to make those decisions, they shouldn't be your healthcare agent anymore. Right. So really looking at that, who's the right person in your life, it doesn't to do that. And where are you at with your own health? Some people do write these documents when they are faced with, you know, a terminal illness, and that might be a different healthcare directive than someone who is healthy and expects to live another 30 some years. So, but I think the big thing about the caution I have for healthcare directives is that you are giving this power to someone else when you are no longer able to execute that power. So is that picking the right person, I think, is really the most important part of that, and having those hard conversations, which frankly is probably why I haven't done mine yet, right? Is having those hard conversations. So are there any questions right now, Amy? Or I'm going to pass it off. I always talk too fast, but hopefully gave you guys an overview of that. And we'll pass it off to Joy to talk about powers of attorney.
I do not see any questions at this time.
So when you hear powers of attorney, you should all be switching your brains now away from medical decisions to finances and property. All right, there you go.
Hello. As Anne said, the big thing with powers of attorney is it is a financial document. It is it's a document that allows somebody to help you with your finances and or property. It's going to help you make the decisions regarding your money and property. You can create the power of attorney when you have capacity. And that's an important thing to remember, is that you can do it at any time. You could do it now and say, hey, I don't need my children or my husband to help me right now, but I want to have this done in case I do need it in the future. When you create this document, it needs to be written, it needs to be dated, and it needs to be signed in front of a notary public. The form document that we have, it also has your attorneys, in fact, signing this document. So whoever you choose is going to know this document's out there, which I think is really important too for when they need it. And I'd also advise that you make sure your power of attorney have a copy of that document. Personally, I know in my family, my parents created a power of a document years ago. We didn't need it until my dad died. But when my dad died and my mom wanted a little bit extra help, it really helped having this already drafted so that we could get the document and use it right away rather than having to draft it when it was actually needed. And you can also select what powers you want the attorney, in fact, to have regarding your money and property. So in the form document that you can find on Minnesota law mnlaw.org, I believe it is, which we'll share with you later, you'll see that there's going to be about approximately 15 different financial issues that you could check a box saying that you want your power of attorney to be able to help you with. So it could be limited and say, hey, I just want my child to be able to help me with my banking transactions. Or you could give your child or your husband all of these powers. You are going to be the one who chooses what they are allowed to do. But the big thing is you need to draft the document when you still have capacity. Once you don't have capacity, you're not able to do this anymore. And you're also going to need to select whether or not the power of attorney continues only when you have capacity, or if it continues once you're incapacitated. And I kind of already talked about this, but it does have the ability to be effective right away. So once you draft it, you could say, right now, I want my husband to be able to help when I need to call the bank and have questions. Or you could say, children, we have this document that's drafted. Here it is. Here's your copy. And then once you decide that you want your child to help you and be your power of attorney, then you could start using it. But having it drafted beforehand, I think, is really helpful. It has to have that specific language that states that if I get sick and I'm incapacitated, I want my power of attorney to continue. That's called a durable power of attorney. If you don't have that language, or if you don't check that box, and the power of attorney stops when you are no longer competent. The important thing is to remember that this is a shared power. You are going to have the choices to continue to make your own decisions concerning your money and your property. If you decide that you don't want to share this power anymore with your child, and I say child because I think a lot of people do pick their child to be their power of attorney, but whoever you pick to be it, then you can file a revocation of the power of attorney. But the big thing is with the documents, kind of like Ann talked about with the healthcare directive before, if you have this power of attorney and you've never shared it with your power of attorney, it's going to be hard for them to figure out where it is when they do need it. And the other issue is if you have this power of attorney and you and your power of attorney have decided that, or attorney in fact have decided that, yes, we want this to be applicable at the bank, it is very helpful if you file that document with the bank, do it together so everybody knows what's going on. But then let's say that in the future, you decide that this child was not the most trustworthy, which hopefully doesn't happen, but you need to decide that you don't want this person to be your power of attorney anymore. When you file the revocation, make sure that you also file it with whoever had the original power of attorney. So if you had filed that document or gave that document to your banker, make sure your banker also has the document that says this person is no longer my power of attorney, it's been revoked, and give a copy to your attorney in fact, so they have that also. But you maintain the power to say, I don't want this person to be my power of attorney anymore. How are powers of attorney helpful? As we stated before, they're for our finances. It is helpful to allow your attorney, in fact, to act regarding your property and money. You can still act for yourself if you have capacity. So I think the one nice thing about a power of attorney document is that you kind of control what you want your attorney, in fact, to help you with. So let's say, I know with my mom that she had questions this year about how to pick her insurance. By having the power of attorney document, I'm able to, I could before that even be in the meeting with her, but with the power of attorney, if her agent has questions, he can contact me directly and I can talk to my mom because she's comfortable with that rather than her talking to him first. Same thing with the bank. We can talk about that I want a copy of her statement each month to help her with her checking account. And the person gets to choose what powers they're allowing their attorney in fact to have. It's something that can help you with. It's also helpful for if you didn't have capacity, you want to make sure that your bills are still getting paid. If you have a power of attorney, that person can still pay your bills while you are not capacitated. You don't need to be worried about what's going to happen.
I'm just going to jump in 1 second. Some of the other scenarios for a power of attorney, which, by the way, attorney in fact, that is the term, which drives me a little nuts. I had a client come in once and say he needed an attorney, and really he needed a power of attorney and he thought he needed an attorney to be his attorney. In fact, you don't need to be an attorney to be an attorney. In fact, it's just a terrible term that some attorney wrote down somewhere. So it's my little side note about confusing language in this area. When I was in college, this is a long time ago, you guys. So my mother had a power of attorney for my bank account, mostly so she could put money into my bank account, right? And have access to my bank and check my balance so I didn't bounce checks. Sort of before the days of me having enough money, I needed some of that support. But the other time in my grandmother had Parkinson's disease, and while she still had mental capacity, she was really shaky, so she couldn't write checks. So that was another case where she had my aunt be a power of attorney and just sat with her and was able to like help her pay her bills, like physically write the check for her. Just tells you how long ago it is, like everything was by check. But those are other times. To me, and this is again part of the reason, to me the power of attorney, if you trust that person, is so critical. There's so many different ways it can be used just to make life easier, frankly. And if you don't want to worry about paying your bills, you can give someone that power of attorney power and share it with them. All right, I'm gonna let Joy talk again because I just sort of got off on a tangent.
Can I just ask a quick question? So if you have the power of attorney so that it's set up so that they can assist you with your banking, that doesn't necessarily mean they can sign and take money out of your account, correct? That would be a co-signer situation at the bank. Is that correct? Or does power of attorney allow for that?
Well, your power of attorney is a fiduciary, which means they need to act on your behalf. So does that answer the question? So they shouldn't be just taking it out for their own purposes. They could do a transaction on your behalf. So say they took money out of your bank account on your behalf to pay your bill, but they shouldn't be taking money out to buy themselves shoes.
Right.
And that's where people get into trouble, right?
But could they sign a check if they don't have a co-signer situation?
They could sign as power of attorney.
Okay.
As long as you file the document with the bank so that they know this person's the power of attorney and authorized to do that. But that's kind of the pitfalls. What we're going to talk about next with the caution with the power of attorney is you need to make sure that that this person that you're allowing, I'm going to say power of attorney because I like that word better than attorney in fact too, is this person is your power of attorney. And that person that you have chosen has a lot of powers. When you're looking at your bank account, it's not like a guardianship where there's going to be the court looking to make sure that things are calculating out. It's just the power of attorney. So if you have an adult child and mom's in the nursing home and mom's not able to look at her or understand really her checking account anymore, and the adult child thinks like, hey, I'm going to inherit this money anyways, and they go buy themselves a boat on mom's dime, nobody's going to know. That's a power of attorney being bad and you not doing their duties what they're supposed to be. But unless the financial institution reaches out and think there's something going on, it's probably not going to get caught, or another child. So that's why it has, when you're thinking about who is this person, you need to think a lot about who can you really trust. I think we all know family members who you love a lot, but maybe you're not going to let them have access to your checking account because of those concerns about whether or not they really might make some bad decisions when they have full access to mom or dad's checking account with nobody overlooking it, especially if mom and dad were not competent anymore. But the one good thing is that you can write limits and restrictions in the attorney, the power of attorney form that we do have. There's a portion where you could say an X, or my attorney, if you can check and say each quarter I want accounting done by my power of attorney so that you know exactly where the money's going. If you're in a situation where your attorney of fact is kind of doing all your financial portions for you, you can also, it's my understanding, check that you are not comfortable with them writing checks for you and telling your financial institution that that's another safeguard you want, is that they can see how much is in your account, but they can't take money in or take money out of that account. The other thing that you need to remember is that a power of attorney, it stops when you pass away. So when we're thinking about estate planning, you need to have a plan of what do you want to happen when you pass away. Your power of attorney is not going to be able to help you anymore and write checks and stuff. Do you have a will that gives you a personal representative so your affairs continue to be taken care of, because your power of attorney won't be able to do that anymore because they're not a power of attorney. Any questions about powers of attorney?
I'm not seeing any questions in the chat.
We're gonna
Just
whip
a
through this
reminder,
stuff
if you're-
quickly, you guys. We'll just get through it fast. We knew we weren't gonna take an hour and a half, so. This is the website that Joy referenced earlier. It's at lawhelpmn.org. And I really am pushing it for a couple of reasons. Number one, because they do, you can do a little searching and jump around to the self-help library. They do have this power of attorney form. I don't know what happened to my formatting here. They also have the healthcare directive form after the healthcare directive fact sheet. So you can go look at the fact sheets, reviews a lot of the information we've talked about, but the form itself is there. And that's really if you think you're ready to do this document or even just want to take another look at it, lawhelpmn.org has those documents. And I also want to emphasize it because a lot of people use the Google for legal research. And it makes me a little nervous since I do that for my own medical care sometimes, and that makes me really nervous too. I'm sure it makes my doctor extra nervous. This is a really reputable, website. So that's why I also push it, not just for this issue, but other issues as fact sheets on a whole number of civil legal aid issues. So I just want to throw that Law Help MN. It's a little bit like Senior Linkage Line, right? Like we want to know the sources we trust, and we absolutely trust Senior Linkage Line, and we absolutely trust lawhelpmn.org for resources in this area. So other thing just to talk to, there we go. So briefly, what if we don't do these documents? Because many people don't, right? What happens if we don't? And what are the pitfalls that could happen? So for healthcare decisions, the hospital is going to look to the next of kin, right? And that's where, like if it's your spouse and your spouse is there and the spouse is going to make the decision spouse wants to make, that they're going to make those decisions with that person in consultation with that person. But this example I gave earlier is you may have a spouse that doesn't make the decisions you want for healthcare. So that's an issue. The bigger issue, I think, is the fighting family issue, that you look to the family and the family disagrees about what should happen. And it just turns a really heartbreaking situation even worse. So that's what's going to happen. And the other thing I would say is that if you become incapacitated, and Joy mentioned this, and you don't have a power of attorney, but you're still alive, but you don't have the ability to do this yourself, how are people going to take care of your finances and your property? How are you going to do those things? And it may be that you have to get a guardianship over that person. I had a friend who's this was in North Dakota, and dad had a ton of land and really complex financial situation, and very quickly went downhill medically and suddenly was incapacitated and unable to sign a check, sign a power of attorney, right? Because once you don't have capacity, you can't even go back and do that power of attorney document. And he was living for several months with all of these things happening. It was very hard to get bills paid, to know what was going on. The bank couldn't even let anyone look at his records, right? So it was really hard. And a guardianship or conservatorship through the courts, I think Britney Spears is kind of like the famous example now. That's not how most of them are, but it is a kind of a famous example, is a court action where you have to go into court and prove someone is incapacitated. It is a complex process. It takes some time, and you have to say, my loved one doesn't know what's going on. It's particularly hard if they are, if they're on the edge, if it's a dementia or an Alzheimer's related issue where you have to go in and prove that they are mentally not capable anymore of doing it. That's a hard thing, and it takes a lot longer. And so to me, especially, that's the reason you do these documents ahead of time. This goes to your question earlier, Amy. Feel free to interrupt, Joy. I'm just sort of on a roll here. There are other ways to go about some of this planning, and it depends on what your particular financial situation looks like. For most of our low-income clients, that things are pretty straightforward. There's maybe a bank account. There may or may not be a home or whatever. There are just a few couple documents you can do for planning. But there are some things you can do ahead of time you know, they all have a little bit of risk. So understanding what you're doing. So your point about could that person just come in and take all of your money out of your bank account? If you do a joint account, for example, if it's a joint checking account, either party has the full legal right to take every penny out of that bank account. So, you know, be careful who you put on that account, because you both are joint owners of all of it.
And Anne, I think there was a question about that. Someone had been put as a joint on their dad's account, and just the concern about what would happen if he has bills or overdrafts. And I think that is the caution with having a joint account rather than just being power of attorney, is a person could take all the money out and the other person's gonna be responsible if stuff doesn't clear.
Right. You're like a co-owner then. You're not just acting on their behalf. You're a co-owner. And it may work for some people, but it's just these are other planning tactics. But you know, if someone gets paid income comes through the Social Security Administration, whether it be disability income or retirement income, and they're not able to, you could have a representative payee, that person who takes that income and pays bills. There's all kinds of like direct payment of regular bills, right? Maybe most of your bills get paid directly, so no one ever has to write those checks, right? Some of that is planning as well. The other thing is a transfer on death designation. So that can be for bank accounts. It can be, you know, there are deeds you can do that, transfer on death deeds, or you could be a co-owner with the right of survivorship. There are lots of different things depending on what your financial and property situation looks like that could be considered. In addition to the power of attorney. The power of attorney is just such a nice, helpful power. I think as Joy has pointed out, it's really that shared power sometimes to help somebody out who just, you know, to answer insurance questions and to talk directly to someone's bank about a question. So,
And we do have another question.
okay.
The question is, what form do you need to have in place for after a loved one passes and the power of attorney is not able to help then?
I would say, again, depending on, and Joy, feel free to chime in. I was just kind of a nice segue to this, is probably a will, but it depends on what the finances are or the situation is for that person. So the will, as Joy pointed out, the power of attorney ends when the person passes away. That power goes away. So how do you then manage the estate after that, paying the bills, all of those things? Some of those things we just talked about, right? Are you a joint account holder? You know, does it transfer on death, right? You can have your bank account transferred to someone automatically on death. A will can appoint someone who is sort of the personal representative to do those things going forward. And the will is also a document. We're not going to talk a lot about it, but you create it when you have capacity and you say, here's who I want for my personal representative. Here's where I want my property to go. And it directs all that property. It is another advanced planning document that doesn't spring into power until after you die. I don't know if that answers the question. You know, again, property, I think about, you know, I co-own a house with my spouse and it's a transfer on death, right? So I wouldn't need to go through probate or need a will to say that I own that house if he were to predecease me, because that document does it, which is why if you have a very complicated estate, you almost need to list out what is all the property, what will happen to it after I pass away, and decide what are the right tools. You know, did that answer the question?
And I agree with Anne, the personal representative, I think a will is important just to have that, but also making sure that your accounts, if you don't do a joint account, if you just have a power of attorney, have a transfer on death, and that's more estate planning, but just so because I think it's 30 days, you have to wait if you have a personal rep through a will, just so there's not that waiting time, but a personal rep should be able to pay your bills if that's what your concern is.
I think that's why, and this is not an estate planning necessarily webinar. We are not experts there. This is very much just those two documents, right? This healthcare directive, someone to make those healthcare decisions when you're not able to, only springs into power, not able to, and then the power of attorney, which is that shared power on the finances. But there is a whole nother topic area about, okay, what is a will? What are the pros and cons of a will? There are all kinds of estate planning documents depending on the complexity or the amount of money in the estate. Some things are absolutely not necessary. There's also called a small estate planning. It's if you're under $75,000 in asset, there's an easier process to follow. But if someone has multiple properties and complex finances and annuities and pensions and all of those things, that's something that each sort of piece of that might be handled differently, right? Some transfer on death, some maybe need to be going through probate, things like that. So it's a whole different topic, but something to be thinking about, right? It's all part of the same planning process.
And Anne, I'll just jump in. We actually are partnering with an Ameriprise financial advisor who's been in the business for years and years and years, and kind of just to go over some of the pitfalls and different things that he has seen that has kind of tripped people up. And that's
Perfect.
a series of 2 actually. And it's Thursday, March 10th and Thursday, March 17th. And he's going to get into more of like estate planning, talk a little bit more about planning and taxes and that sort of thing, and investments, long-term care, that sort of thing. So I did put the flyer in the chat, but I also, like I said, it will be on our Dancy Facebook page as well. So I encourage you, this was more just kind of to touch base on those 2 basic documents. But if you want more information, those would maybe be good webinars for you to attend as well.
And I think that those are a great addition to this, because for some people, they absolutely need all of that. And for some people, and again, for our clients, tends to be these 2 documents really solve most of those issues, those planning issues, if there's incapacity, right? These are really issues of when you're still alive but incapacitated or unable to do it yourself, or just want the help through that power of attorney document if it's prior to incapacity. I think that's the situation Joy is talking about. She and her mom are working on some of these issues and sharing that power.
And we do have another question. So this is in regards to somebody who resides in a nursing home. And it says, who should advise/assist a person to develop a power of attorney healthcare directive who has no family or and they reside in a nursing home?
That's a tricky one. Well, I think there's two different questions. One is who should advise. I think that giving the person the document and saying, do you want someone else to have this, to make these medical decisions for you? Keeping in mind with the healthcare directive, they could just write down their wishes. They don't have to appoint an agent, because it feels like this is a situation where the person doesn't have family, friends to be that agent. So on the healthcare directive side, my first thought is that they could write down their wishes, and then that could be used to guide any healthcare decisions in the future. So the healthcare one is a little bit easier because you can write down your wishes. I think for the power of attorney, who could that person be? Right? Like, I would be nervous about having someone who works at, if there's any conflict of interest, I'd be worried about that, right? So I think of the sort of most obvious conflict of interest. If someone works in a nursing home, you wouldn't want the person in charge of finances at the nursing home to be the power of attorney. I mean, it makes sense because you want to get your bills paid, but there'd be for in the social service. I don't know, Joy, are you looking at the question in the chat? You guys are giving a, see what you think.
She's asking, is it a conflict of interest for social services in the nursing home to be the power of attorney?
As long as that, here's my classic lawyer answer. As long as everything goes fine, it's fine, right? It's, if there's ever a question about should this bill have been paid or that bill have been paid, that's where it would make, I mean, but lawyers, let's be honest, right? We are nervous about worst case scenarios. Yeah, see, Jennifer, that's me. It feels like, oh, that feeling.
If I was a social worker, I don't think I'd want to, just because of like, I guess you could really limit the power of attorney. I'd be nervous to just have that duty to the resident. And what if other bills aren't getting paid, but the facility is getting paid? Is that ever going to cause an issue that was the priority?
The other thing I would say would make a difference on that conflict issue is, does the person have capacity, and are you providing them with the information to have a check and balance in place, and the power of attorney document allows you to do that. So you could put in the power of attorney that you have to do an accounting. And if that person is competent and you look at the accounting and they say, you know, you could protect yourself and say, yep, that's how I wanted the bills to be paid. I just was, again, I go to my grandmother's. I was physically unable to do that, but thank you. You helped me get the bill paid. There's at least some protection there. If the person has any question about competency, that would be, you'd want a third party, I think, in there. I think they're in the chat, someone saying like LSS or adult, somebody else to be helping with that. There might be other things other things to do depending on that person's situation. And I can't imagine that it is rare, right? That may happen from time to time.
And so some of the kind of follow-up comments are that there could be liability if social services is involved. Somebody said services would do that. Another person said, shouldn't they have a conservator? And then they suggested LSS or adult protection.
I think that's the factual difference too, right? Is that person competent and understands that because if they're not competent, they can't execute the power of attorney anyway, right? We've already crossed that bridge. And then you would need to have something in place to get that money to the facility or other places bills need to be paid. And that's probably a guardianship conservatorship. Which those are not easy cases. I mean, they're not hard in the sense, but they're a lot of paperwork, right? It's not, you can't just hand someone a document and get a conservatorship over mom, for example. Because if the person's not competent, it would have to be, because no one else has the power to decide anything about their finances. If they're the only ones in the bank account and they're not competent anymore, there's going to have to be a guardianship. I know that there's always a struggle with the counties, like when do the counties step in and do that action? The other thing I would say about a guardianship is it should be the last resort. It absolutely should be the last resort. There's a nice push, and I think it's a good thing about supported decision-making, right? Even someone who maybe struggles a little bit, but how can we support that person? And that's a whole topic for another day, is that supported decision-making. Or is it truly the case where that person needs a guardian because they are unable to be safe? I think this is just my opinion, does not necessarily reflect the legal services of Northwest Minnesota. A lot of times people think this person needs help, they need to have a guardian over them. A guardianship should be the last resort. And what are the other supports, these documents, all of the other supports we can put in place? Because to me, a guardianship is someone who is going to make decisions that are going to make themselves or others unsafe. And lots of times, if someone's in a nursing home, they're not trying to go live on their own. So you don't have to decide where they live. They understand they need to live in the nursing home. My grandmother, who like I said, had Parkinson's and then went through years of dementia, never had a guardian over her. She would have been completely unsafe to live on her own. Would have been completely unsafe, but she didn't ever try to. She wasn't trying to make decisions that were going to be unsafe for her. So we didn't have to go to a guardian. You know, those other documents in place helped. But that's just my own personal thing about guardians, I think. And I don't think people mean it in a bad way to jump to guardian. I think the other stuff is harder. It is a lot harder to do the supported decision making and to put those other documents in place. Well, it sounds like someone has capacity. Yeah, I think you're right though, Jennifer. I think that's an important point, is as we talked today, we talked about your, adult child or your spouse. Those are kind of the obvious ones. It wouldn't have to be that person, but it does have to be someone that they trust, probably who doesn't work for the facility. So who is that? If anyone knows the answer, I would love to hear what the solution is to that.
Somebody commented rep payee agencies.
Yep.
That's what I was.
Yeah, and that's, I guess, the professional third party that I'm talking about. So it's not the facility. And if you don't have family or friends, you could have, there aren't as, you guys are the experts more than me on this. I don't think there are enough of them. I think we need more. I think as the population ages, it's all of the issues that you guys are probably dealing with. If you are professionals dealing with seniors, care providers, rep payees, all of those are in short supply.
And then Jennifer followed up. She said she was going to ask what agencies are best in this area. And I think by area, she kind of means, well, I know where she's at. She's in Pelican Rapids area.
Okay.
So do you know a specific? I know Lutheran Social Services is statewide. So I would probably start with them and they might have some recommendations for some more local.
And I wonder if adult protection, like the county doesn't want to do it, but they may know, they would know the providers in the area. I would go to an adult protection worker potentially for a referral. I think the adult protection workers too, and again, this isn't exactly what today's webinar is about, but some of this comes from the idea of protecting, especially the power of attorney, protecting people from financial abuse. You know, obviously that's the big risk with the power of attorney, but not just a power of attorney, but the idea of financial exploitation abuse is a really serious problem. And so that's the other thing adult protection might get a sense of is, you know, if there's any issues there. And that's where, and Joy said it multiple times, but I'm just going to say yet again, is picking a power of attorney that doesn't have their own financial struggles, ideally, and also that you trust. They need to be using that money for the, I want to say protected person. The person doesn't need to be incompetent, but for the person that they share the power with. And I think your point, Joy, that I'm going to inherit this money anyway, or mom would want me to have new shoes. It's when people cross over from doing it for mom and doing it for themselves. And that's when they've really crossed an ethical line and potentially a criminal line too.
And I think I've talked a lot about the scary things of what a power of attorney can do because you give them so much power, but I think we also need to think about the good things that they can do, that if you have a power of attorney who's doing a good job and making sure mom's money is accounting right, they're going to see too if somebody is scamming your parent and taking money that's not authorized out of that account, or why is mom giving this person all that money? So there's a lot of good things that powers of attorneys can do. I just think it's always, you got to be really careful about who you pick to be your power of attorney.
I have another question. I've seen some documents where people just like X'd through things and initialed them and changed them and dated them and that sort of thing. Is that legal?
You mean when you say that, is it like they took the power of attorney form and they like updated it, or the first time they signed it, they said, not this?
No, they it and then just a date and initial. I would think they would have to do a completely new document to change things on it, but I've seen that where people have done that.
So they say they sign it in January, and then in June they decide, I don't want you to have this power, and then they cross it off and date and sign it.
Right.
I don't know, Joy. It makes me nervous, but that's our job, is to be nervous about everything.
I think it's legal if you initial it and date it, but I don't like it. I'd advise you to redraft it.
Whenever there's a potential for confusion, right? That's when we always get nervous. And I will say too, sort of the law and action part is, if nobody ever looks at the document again and there's never an issue with it, it's probably fine, right? If you have one child and you change it and it's whenever something goes wrong, every little potential for confusion is where things go bad, right? That's where that question of what date was this really signed, and did mom really want to change it on this date because it just crossed through an initial, you know, especially if there's a lot of money involved, and that's where things get weird. That's the same with confusion does happen daily, Jennifer, daily. And same with that capacity issue. If there's a question about was that person able, I would put some document, were they competent to sign that power of attorney, that durable power of attorney? Were they competent to do that healthcare directive when they did it? If there's going to be if no one ever fights about it, no one cares. But if there's an issue, you're going to want to document, whether through if there's any question at all, I would want probably a medical statement saying, I, Dr. Smith, know the patient and she's great. She totally understands what she's doing on January 10th when she signed this document, and just put it in a file somewhere. But again, that's a lawyer talking, where we worry about, we spend our whole day saying what could possibly go wrong. It's not a healthy place to be necessarily, but we err on the side of caution, I think.
All right. How about more questions? Anyone else have any other questions?
I would just add that Amy has our contact information. So if a question arises, sometimes people 30 seconds after we all get off go, oh, I should have asked that, or I didn't want to ask it publicly. That's fine too. Amy has our contact information for sort of general advice. I want to give specific legal advice necessarily, but happy to answer those general questions.
And if the individuals on the webinar, if they have a client that they think is inappropriate, or if they themselves have questions and they're an appropriate referral, how do they go about contacting you just as a general intake?
You know what? I will put that in the chat.
Okay, perfect.
Whoops. I will try and put that in the chat. I'm going to put the general number where someone could call for an application. And then our website as well, because you can apply online. So, and again, we cover 22 counties in Northwest Minnesota and all of the 21 that you guys cover. So I would think we are the appropriate agency for everybody here. We're also happy to do this presentation or tweak it or do something else. You know, Joy and I are happy to take this on the road. Probably not literally right now. This has actually been great to see all of you guys, even though you can't see your faces, see all across 22 counties or 21 counties. You know, for staff or for a senior center, or I'm trying to do two things at once.
All right, so Ann did put the number in the chat. So it's 218-233-8585. And that's for Legal Services of Northwest Minnesota intake line. And then she also put the website lsnmlaw.org. And then Ann and Joy, are you able to share your PowerPoint and I could send that out to the registered? Perfect.
Yep.
All right.
I will amend the final slide and I will include that phone number and the website too. So, and our names are in there
Perfect.
somewhere. So
Perfect. Sounds great. Any last questions before we depart? You get some time for your extra lunch. Having extra time is a good thing. All right, I'm not seeing any other. I'm just seeing some thanks. Thanks for the great info.
thanks for sharing an hour with us, you guys. Appreciate it. All right.